that's very helpful, thank you.
So next, I want to address grounds 10 and 11, which relate to the judge's findings on the sign, and in particular, one point of ground 11 about the impact of that. My learned friend didn't expand his submissions on this orally. I think in light of that, there are only 2 points I need to make. One, my Lord Justice Arnold already anticipated yesterday, and that relates to ground 11, as to what is alleged in the ground not quite marrying up with what the judge actually said, and perhaps for completeness, if I could just run through that. The grounds appeal core bundles have 1 page C, core bundle page 16, ground 11 starts at the very bottom. In particular, the judge also erred in apparently considering that the fact that the sign is printed on a cylindrical surface of a can is a point of difference from the trademark. And the point I was going to take from that, I think, is hopefully the same point that my Lord Justice Arnold was flagging, is that that's not quite what is said in paragraph 74 of the judgment, which is at tab 7, page 118 of the core bundle. And at the very bottom of that paragraph, it starts, Mr. Howe invited the court to compare physical mid-page Thatchers product, which bears the trademark of the Aldi product, saying that will demonstrate conclusively the similarity of the trademark and the Aldi product. In my view, it is permissible. Thatchers have chosen to do this case such that I must compare a 2-dimensional mark, being the trademark, with a 3-dimensional product, being the sign. So it's not her making a finding that is a matter of the law. It's impermissible to compare something 3D with something 2D. It's a different point which goes to how the matter was pleaded. So I don't think that...
Sorry, I don't quite understand that. What's it got to do with the pleading? Because I don't think anybody's disputing that the trademark is inherently 2-dimensional. But as I understand it, the point that's being made under ground 11 is that the sign is also 2-dimensional. It's wrapped around a cylindrical can, but it's nevertheless a 2-dimensional sign.
So I think in that case I clearly did misunderstand what the what you put to Mr. Hammond yesterday.
Well, no. What I was discussing with Mr. Howe was a slightly different point, which I think is more relating to ground 10, which is to do with the point that regardless of how either party pleads its case with respect to the sign, at the end of the day it's for the court to decide what the sign is, and we'll come back to that in a moment. But as I say, I think that's more relevant to ground 10 than ground 11.
Yes, and I was going to come on to that in a minute, but I think the way that I'd understood ground 11 is alleging that the judge made a legal error in finding that that there is a point of difference based on the 2-dimensionality of the trademark compared with the 3-dimensionality of the can, and then therefore excluding of any relevance the fact that the trademark has been used 3-dimensionally on a can. What I'm submitting is that's not what paragraph 74 says. She's not saying that she is entirely disregarded because she can't, as a matter of law, any evidence of the trademark being used in a 3D way. She's simply referring to the fact that she can't take a shortcut by holding up one can and holding up another can and making that comparison, which is what my learned friend was suggesting she do at trial.
Ah, well, if that was the suggestion, then I would agree with you. That would plainly be impermissible because as I think is inherent in your submission, you've got to compare the trademark as registered with the sign as used.
Yes,
but
in my
sorry, do go on.
I can say in my submission, that is all the judge said. The bit I just picked up, she says, Mr. Howe invited the court to compare the physical Thatchers product, which bears the trademark, with the Aldi product. So all she's saying here is, well, I can't do that. I need to look at how the sign, how the mark is registered and the sign.
Ms. Wickenden, she does go on to say that is of itself a point of difference between the two. Isn't that the point that's picked up in ground 11?
So in my submission, was right for her to consider that as a point of difference.
Right, but that's what. Sorry, but reading back to ground 11, that seems to link to that point as far as I can.
So ground 11 makes the express reference to paragraph 74.
Yes, the first two lines of ground 11 refer to point of difference.
Yes, so to the extent that she took into account that as a point of difference, I'm simply suggesting she was right to do that, because you have a figurative mark and she has found the sign to be a three-dimensional can. And that's another important fact to note. She didn't find...
I don't understand that. How can a can be a sign? Well, it's the surface of the can that is the sign.
Well, that is very much my next point. But the way that she defined the sign was as it's been referred to in the paragraph 17 of the particular claim as the overall appearance. So that includes the three-dimensionality of it. There was no finding that she found the sign to be specifically the images printed.
But this is a case that's all about the images on the can. It's completely unreal to say it's about the can itself, isn't it? Which is a conventional beverage can, 440 millilitres.
Well, this is a problem that's arisen from the way that it's been pleaded in a variously inconsistent way. There's reference to graphics on the can, which were non-specific. Then there's reference repeatedly to the overall appearance of both the can and the 4-can cardboard pack. And the point that we took in response to that in the defence was effectively that there hasn't been a clear case pleaded on what the can actually, so what the sign actually is. Perhaps I need to take you to
Okay.
the pleadings. So at perhaps if we take it to pick up the particular claim, which is at tab 9, core bundle page 163. So paragraph 14 there first defines the Aldi product, and that definition comes from simply a cloudy lemon cider product, an illustration of which is below, and that's the...
I beg your pardon, where are you?
Sorry, we're at paragraph 14 of the particular claim,
Right.
core bundle page 163, the definition of Aldi product at the very bottom.
Right.
So that's how it was first introduced, and then there's an image below which is the of the 4-can pack. Then at paragraph 17, there's an allegation that in designing the appearance of the other product, in particular the graphics on the cans and 4-can cardboard pack, there's intentional mimicking. There's then further reference at
see if I can tease this out. So, in paragraph 19, it says, in adopting and using the graphics on the Aldi product cans or cardboard or can pack, the defendant has used in the course of trade in the UK without the consent of the claimant signs which are similar as the trademark. Now, does the reader not understand from that that the signs being complained of are the graphics?
Well, yes, but it wasn't clear whether it was every single graphic element on the product.
It's the totality of the appearance, isn't it? Don't they make that clear?
Well, yes, so they do. We get there that it's the totality of the overall appearance. What we don't get is that it's without reference to, as if it were a two-dimensional sign printed on.
But the appearance is all about what is printed on the surface. You
Yes,
can't have thought that this was a complaint about the shape of the can you?
So, given that they continually insist that it's the overall product and they complained of the product as an entirety, that did lead us in the defence to effectively take the point that it wasn't sufficiently clear what was being complained of. Obviously our concern was to fully understand, well, are you just complaining about the overall appearance because you don't want to specify that the similarity is in the particular descriptive terms? This was an issue that was obviously important for us to fully understand, and it's not really about whether it's a three-dimensional can or not. It's the point of that we're considering the overall appearance of a product, rather than suggesting that the consumer would see the product, do the mental analysis and think, well, what would that look like if it was a two-dimensional figurative sign? Our primary point has always been that it's artificial to suggest that the average consumer would look at the Aldi product and understand that the totality of all of the graphic elements was a sign. Likewise, that
Well, that is a submission I can understand, and that has a certain resonance with me, as I was pointing out to Mr. Howe, because, you know, if you look at I gave the example of the Yorkshire Rosette case, and I didn't agree with the way either side was characterising the sign in one instance. I mean, in the other case I did, but in one of the signs complained of, it didn't seem to be that either of them were right. And so I made my own assessment of what the sign was, viewed from the perspective of the average consumer. So I can quite understand a submission that says the sign is not as defined by Thatchers. But if you're going to make that submission, the follow-up needs to be what you say the court should conclude the sign is.
So perhaps if I could just take you to the skeleton argument and show you how this was run at trial, because I think we were trying to make a similar argument to your lordship, but in a slightly different way. This is covered in the it's tab 12, core bundle, page 238. And the relevant paragraphs are 51 and 52. And effectively we're saying we think it's artificial to define the sign in that way, but given that's what you pleaded, that's the case you've made, and you're stuck with it, as it were. But perhaps if I could just ask you to read 51 and 52.
Right, but the punchline seems to be the sign comprises all the components visible.
Well, because that's what they've pleaded.
But it's not a submission that they're wrong and the sign is something different.
Well, paragraph 51, it's difficult because all of the power of defining what the sign is with the particulars of claim.
No, because the court can decide, and if you give me a submission that the sign is something different, I'm capable of accepting that submission.
Yes, I just wanted to try and understand how we've got where we are. So usually, in a particular claim, you would have a clear paragraph saying this is the sign, to which the defendant could respond and say, I accept that's the sign, or I do not accept that's the sign. How the defence was pleaded, given the lack of specification of which graphics, also references to overall appearance, reference to the Aldi product actually being the product itself and not the images, the defence was effectively, you have not pleaded a sign to which we have a case to answer. The reply then came saying, we are clear, we refer to the overall appearance. So in that context, especially given at the CMC, this matter was raised, again emphasising the overall appearance, the submission at trial were effectively, well, we don't really think this is a sign, because the signs are, as set out, torus, the full head, and then there are a number of decorative and non-distinctive elements, which are alleged to be similar. So either the signs really are torus, bull, and these decorative elements which aren't signs, or if you want to say that there is an entirety of the sign within the can, those elements are non-distinctive anyway.
All right, but that leads to this question. I can understand the submission that says you need to dissect this, and in fact what you find on the surface of the Aldi can is a multiplicity of signs. But that's not what the judge found, and I don't believe you've got a respondent's notice saying that that's what she ought to have found.
I agree, there's no response notice on that point, but given the indication your lordship made yesterday, if maybe that this is not what you're considering, but if you were considering making an assessment afresh of what the sign is, given that the definition of the sign is an issue, the appeal on the basis of grounds 10 and 11, it's only right to have some consideration of how this was run below. The only other point where it may also be relevant is in relation to an intention to have brand significance. Because given that we say it's artificial to consider the entirety of the can as a sign, it follows that it would be artificial to sort of import some intention of brand significance in those elements which we say are only part of the sign, because that's effectively how it's been found as a matter of pleading.
All right, but can I be clear as to what your case is in this court? Because Mr. Howe has a ground of appeal saying that the judge has mischaracterised the sign, at least in terms of identifying a point of difference because of 2 dimensions versus 3 dimensions. And I'm left unclear as to what your case is, because you make the point, and I understand that what you were saying at trial is this is not one sign, it's a multiplicity of signs. But as we've established, the judge didn't find that, there's no respondent's notice. So what are you saying the judge ought to have found constituted the sign?
So in terms of the appeal ground 10 and 11, the narrow answer is that we say that there is no error in her considering, in theory as she seemed to do, a point of difference from a 2-dimensional trademark and a 3-dimensional sign. As it seems to be common ground between us, that didn't really seem to affect any of her reasoning in a material way. So the short answer is really that we think she was right to flag that point, but it doesn't seem to go anywhere. I only raise the broader point about what was wrong below in response to your lordship's raising the additional factor of whether it was right for the judge to be confined to one or the other, just in case the court is considering of going, as I say, a third way. I draw these points to your attention.
Yes, and I'm grateful, but I'm looking for the bottom line. if we go down that road, what do you say the bottom line is? What should we decide?
That there was not a single sign on the can. The sign was sign used were Taurus and the bull element, and then there were decorative elements. Whether those were found to be separate signs or not, they were ultimately decorative and non-distinctive, and will not give rise to any actionable similarity.
Okay, thank you.
So do you say that the Thatchers can does not display the mark?
So the exercise that has been done is the appellants want to register the surface of the can, and they've registered effectively a net version of that. It's printed on the can. I don't take any point with that. I'm not suggesting that the fact that it's been printed on the can means that it doesn't display the mark. But just because the appellants have decided that their whole appearance of the can has brand significance and that they've registered as such, doesn't mean as a matter of fact that consumers are going to decide to think that either the entirety of their can or the entirety of the Aldi product, all of that messaging is that there is brand significance. And this really goes back to Learned Leader's overreach point, which was referred to earlier, and I think we may well come back to.
Yeah, well, that point I do understand.
I think that's, if there aren't any further questions, I think that's everything I wanted to say, which would take us to our respondent's notice. The first point of which refers to the similarity of signs. The only thing I want to, that doesn't take us to our respondent's notice, I just wanted to indicate while we're here that I don't think, in light of what we said, I need to say any more about respondent's notice ground 1. But I will refer back to my learned leader, who will now deal with the point on whether you should consider diverging on L'Oreal.
Thank you.
So, my lord and my lady, if I may, I was going to deal with the issue of divergence, which arises in the nature of our response to my lord friend's grounds of appeal. But then, subject to your lordships and my lady, I was going to deal with the respondent's notice, grounds 2, 3 and 4 together. And again, if my learned junior might deal with the 5th one, which is the section 11.2b defence.
All right.
I was going to deal with these quite briefly because for the divergence point, we've set it all out in detail in our appellant skeleton argument of paragraphs 43 to 49. And in the context of intellectual property matters, there's really only one case, which is the ICE case. We say that, and for the reasons that are elaborated in those paragraphs, that this would be a suitable case if you were so minded to diverge from the L'Oreal jurisprudence. But we say that really is only our ultimate fallback position. And the reason for that is, in the cascade, we first say that this case is outside of the reach of L'Oreal because it's not an imitation case. There is also no finding of advantage, and there's no finding of intention. So therefore, L'Oreal, we say, does not touch in a material way upon the determination of this case. So you don't need to diverge because you don't need to differ from it for here. If the way in which L'Oreal is construed within this court, the way in which we would imagine that to proceed is that could only really occur if you're not giving sufficient weight to the word unfair in the phrase unfair advantage, in the sense that there's some sort of assumed unfairness if other elements are there, which of course we say aren't, but I'm now arguing against myself. Now, in that scenario, where in essence, because of some elements, you do not need to pay any particular attention to the word unfair, you can still reach the conclusion that there's an unfair advantage and so find against us. We would then say two things. The first of which is we would raise the due cause point, and to address the logical inconsistency or anomaly.
Sorry, you don't have a respondent's notice on due cause.
No, but due cause.
There's no finding of the judge.
There's no finding of the judge, but the point being is that if there's no finding of the judge, then, you know, well, let me deal with the point.
Sorry, I'm baffled, Mr. Edinburgh.
Yeah.
I'm very sorry. I thought you were addressing us on departure from L'Oreal, and I understand you're trying to put this into context by saying that this, you know, you've got plenty of submissions that Mr. Howe has to overcome before this becomes relevant.
Yes. That
point I clearly understand, but without due cause, it's got nothing to do with it, because there's no finding of the judge and no respondent's notice.
No, but let me just explain how, because my lord raised this point that in unfair advantage cases, you're saying that due cause could never arise.
No, that's not what's been said. That's not what Little and Tesco says. Little and Tesco highlights the paradox that the statute seems to envisage, that you can have an unfair advantage with due cause.
Yes.
And that seems like a strange proposition. And Lord Justice Lewison in particular thought that that was an oxymoron.
Yes, and I was going to try and put forward why, if in construing L'Oreal in such a way that you don't give any weight to the term unfair, then that would remove the strangeness of then finding that there is some due cause. Because what one hasn't really done is given any weight to the unfairness and the unfair advantage. And so therefore, you don't have to overcome that sort of hurdle when you're trying to do the mental gymnastics to see whether or not there is a due cause. But
that seems to be an argument in favour of the proposition that unfair is a low hurdle.
But I'm only getting there.
Which is surely not what you're arguing.
No, I'm only getting there. This is my third fallback position in a sense. If you've construed L'Oreal so widely, and I say wrongly, but my last fallback position is, if we've, on your lordship's and my lady's construction, we fall within L'Oreal and somehow we fall foul of it, we would then have a section 11.2b defence. And that is in the respondent's notice, and that's what my learned junior is going to address you with later.
Yeah, but that's a separate issue.
Yes, exactly. So I'm just trying to do it in a series of small steps. But we say only if you find against us on everything. So you've now found against us, for example, even on 11.2b. It's only at that stage do we suggest that you would need to diverge.
Yes.
Because at that stage we say that the balance with respect to fair competition and protecting the proper rights of a trademark proprietor have swung too far in one direction, namely against free trade. So what I'm trying to say is, really, you have to find against us on so many different things before you even come to a situation where you need to contemplate whether or not to diverge. And at that stage, the only way you could have got to that final position where we're seeking a divergence from the case law of L'Oreal is because the balance between free competition and proper protection of a registered trademark has been improperly struck.
All right, so all of that confirms where you started from, which is that this is a submission of last resort, and we understand that.
And that's all I was. But I was trying to put that submission in context, showing you how far last resort it was.
Right. But you're still making the submission, so we still have to understand what the submission involves.
Which would be to diverge, which
Yeah.
would then be, sorry, my lord, were you about to say something?
Yes,
Sorry.
well, because, and I appreciate you are coming to this, but it's all very well putting it in context, and I appreciate that. But at some point, we're going to need to know what legal test you invite us to substitute for that enunciated by the Court of Justice.
The point would be we would then pick up upon the criticisms of Lord Justice that were expounded by Lord Justice.
But it's all very well to say that the test propounded by the Court of Justice is unsatisfactory. It doesn't get you anywhere unless you are capable of propounding a coherent alternative. And forgive me if I've missed it, but I don't find in Lord Justice Jacobs' scathing critique any alternative put forward.
Well, yes, you are right in that he didn't put forward an express alternative.
Nor do I find it in your skeleton argument, which is why I'm asking the question.
My lord. But the point being is, we would say, picking up upon the critique put forward by Lord Justice Jacob, is that you have to find the right balance between free trade and competition and the rights of proprietor. And we say that
Well, that's Appellant and apple pie and motherhood.
Yes,
Great,
yes.
But, you
Sorry,
know,
I was just about to follow through. And that can be tested with whether or not the thing that the defendant is doing, which is in this case, is the only commonality are based upon descriptive terms or commonplace terms.
that's a submission about the facts of the case, not about the legal test to be applied.
Because the facts of the case will then inform upon the legal test, and the legal test will be that if only descriptive or decorative elements have been taken, then that cannot and should not fall within the scope of 10.3. That's the legal test, and it's how it appertains to the facts here.
How is that a legal test? The question is, how is the court to determine what is unfair as opposed to fair? How does a test which is all about the facts of one specific case enable the court to do that?
Because the test is, has that which has been taken merely descriptive, decorative, non-distinctive? If the answer to that question is yes, then it should not fall within the scope of 10.3. That is on a case-by-case, multifactorial global assessment, which harks all the way back to what the Attorney General said in, sorry, not Attorney General, the Advocate General in paragraph 80 in L'Oreal.
As I understand it, you say that this doesn't arise unless we determine that there isn't what you would say is sufficient weight to the concept of unfairness.
Yes.
So surely all you need to say by way of divergence is that we should diverge then by giving greater weight to fairness.
Yes.
And isn't that the end of it?
Well, yes, but the...
In other words, if we don't win on what we think L'Oreal, you want us to reinvent L'Oreal as you have submitted it.
Yes, in short, but the way in which you do that, so as to give some guidance to other judges in other situations, is when you come to give greater weight to the unfairness-fairness divide, is to see whether that which forms the commonality between the sign and the trademark are merely descriptive, decorative.
That's not giving guidance in relation to the test going forward. That is just simply applying your facts of this case to what is fair.
It's sort of saying, please don't do a global assessment where everything's taken into account, because if your points of similarity are those descriptive or decorative elements, then that's sufficient, don't go any further, there's no unfair advantage.
Well, the way in which the test is currently put forward is that you have to take into account everything, but there's no greater guidance than that. What I'm trying to say is that the guidance from the court ought to be that when you take into account everything, it's an important factor that if the only commonality arises through these decorative, non-distinctive, whatever points, then that should point towards it being fair, not unfair.
I think you're saying it should be a determinative factor.
Yes.
That's the way you're
yes,
putting it.
yes.
Not
But the point being is that if, well, determinative, not necessarily, because there might still be an element of intention that could override everything. That's a potential argument that was the second argument of my learned friend when he was distinguishing from intention being merely an evidential point. Because otherwise, you see, what one is heading towards is if the only things that have been taken are decorative, non-distinctive terms, then you're heading towards a tort of copying, straightforward copying, where in circumstances there's no copyright infringement being established, there's no passing off being established, or any other wrong being established. And there's judicial comment that there is no tort of copying per se.
No, you have to have a relevant right.
Yes. I mean, shall I just give you the reference for that because there's no need to go. But it's the Hodgkinson case. It's the Authorities Bundle 2, tab 11, page 395.
Yep.
We don't need to go there because that's all it says of importance to this case. That was Mr. Justice Jacob in a sort of one of these mobility cushion type cases. I didn't want to spend any more time on that because in my submission it's very unlikely we get there.
Okay.
I was trying to spend an appropriate amount of time for the probability that it turns up, if you see what I mean. We then go to Respondent's Notice 2, 3 and 4. And I was going to deal with these also relatively quickly, if I may. The Respondent's Notice 2, I deal with this in the appellant skeleton at 64 through to 80, and it cross-refers to the judgment in paragraphs 114 and 115, which is in the core bundle, tab 7, page 36.
I beg your pardon, can you give me that again?
It's core bundle, tab 7, page 136.
Thank you.
Paragraphs 113, 114.
Yeah.
And leading through into 115. Of course, in my position, I don't really wish to criticise that which the judge has said too much, but it is arguable that in 115 she slightly muddled the terminology of goodwill and reputation, because this is under the heading of issue 1, does Thatchers have a reputation in the UK in the trademark? So the term reputation is being used in the trademark sense. And then in 115, sentence 2, let us remember what goodwill or reputation is. It is the attractive force which brings in custom. And then she refers to the Muller-Margarine case. That's in the context of what is goodwill in the context of the tort, the common law tort of passing off.
But isn't the explanation for that she's trying to deal with things compendiously? Because when one looks forward to paragraph 145, where she's dealing with goodwill, she says, for the reasons I give in relation to reputation, I'm satisfied it does. So
yes.
What she's doing is she's wrapping up the reasoning on both
Yes. But that's,
subjects. But do you criticise her for doing that?
No, see, my lord, that's why I was treading very softly upon this, because, my lord, that's exactly what I've been saying with respect to the appeal, is that some things she was dealing with compendiously, and you shouldn't, in essence, scrutinise every word and every phrase far too closely and say, this is a minuscule mistake that she has made, therefore we can undo it. She has, as is appropriate in IPEG, dealt with things in an appropriate manner. And in 115, as you say, then cross-refers through to 145, she's dealing with things, as you say, compendiously.
Why does it make a difference here? Why might it make a difference that she has made a
Because if you turn the page, my lady, still in paragraph 115, can you see the way in which she's picked up the term attractiveness from the quote from Muller Marjorie?
Yes. And
then she seems to be using that in the sense of that the product is attractive in the sense it has shelf attractiveness. It's a small point. All these are very small points. That's why I'm not going to spend too much time on it. But that's why there's a small point there that she seems to be potentially taking the definition from in passing off, which uses the term attractive force, and then cross-relating that to shelf attractiveness. And I would say that relates to things like nice colour schemes, images that tell you what's in the can and what have you. Because of course you don't want to put on a shelf something that's unattractive. I mean, that's the whole methodology behind the plain packaging for cigarettes. They're supposed to be sold in packaging nowadays that does not attract people. But that's separate from the trademark rights. Now, as I said, I don't want to labour these too much, but that's a small point. Respondents notice 3. This is very much a matter of nuance. And if I can just start this off and lay the foundation, is that if one were to have a 3-dimensional trademark, then it's accepted that, sorry, not accepted by my learned friend, it's just accepted, I would say generally, that if you have a 3-dimensional trademark, you nearly always need to educate the public that the shape is acting as a trademark. Because people broadly do not look at a shape and think, trademark significance. Now, moving it closer to home, if you have a descriptive term, like a lemon for a lemon product, be it a picture of a lemon or what have you, then you need even more education of the public, and this time because you need to disabuse them that it's not being descriptive and is in fact being used in a trademark sense. And the way in which this flows into my argument about the fact that the trademark is a 2-dimensional trademark, it's a 2-dimensional figurative label trademark. Now, let's just start for a moment with a simple example. You have a nice word with some graphics around it, and you just have that as a 2D figurative mark, and then you place it in the centre of a piece of packaging. And it's fairly clear that the focus of the consumer will be upon that central issue. And the rest of the packaging would probably be ignored. But what one has here is a figurative trademark. There's nothing wrong with that. It's a 2-dimensional figurative trademark, the validity of which is unchallenged and potentially unchallengeable. But the difference between the first example and this example is that in this case, the label is being used to cover the whole surface. And in my submission, the normal perception of a consumer when they look at the whole surface of a product is that they would not think that the whole surface is acting as a trademark unless you educate them. And so in this case, when you look at the 2D trademark being applied to the three-dimensional can, there's nothing wrong with that. But the consumer's attention would be focused upon the central part of the can, in this case Thatchers and what have you, you know, the established in 1904 and those other elements. But you'd need to educate, in my submission, the consumer that in fact all the other elements that are just filling up the surface of the can, which are the normal places for decorative, non-distinctive elements to occur, are actually intended to act in some form of a trademark in this case. So that's the nuance with respect to the 2D, 3D point. It's the difference between a 2D trademark that is now being applied to a 3D surface to cover the entirety of the surface.
This isn't necessarily between 2D and 3D, because just taking your
Or
earlier
the
point,
whole packaging.
if that packaging had got Thatchers and the lemons in,
And then
you're saying in the centre with
Yes.
a plain surround.
the same
it would
argument
be-
applies. Yes.
It's okay. So
Yeah.
it's not necessarily between 3D.
Sorry, you're absolutely right, my lady. The reason I was focusing upon the can is because the way in which the sign is currently defined is as the application of the sign upon the can. But it would also, my argument also applies to the packaging. So, if I may reach across. So, not yet. The point being is that it's covering the whole of the packaging. It's as simple as that. It's only a nuance point. But when you as a consumer, or one as a consumer, looks at the whole packaging, be it upon a can or be it upon this sort of packaging of the 4-pack, is that they're not normally used to seeing that every corner, so to speak, has trademarks.
Okay, I mean, it's probably unnecessary, but most cans and 4-packs are printed with covering the entirety. I mean, Coca-Cola, you can notice what a Coca-Cola can looks like.
But the point
so
I don't understand why this is a point of law. It's surely a purely factual question. I mean, you know, the famous example in this context, this shows how old I am. I mean, this is 20 years ago at least.
My lord, you're younger than I am, so...
20 years ago at least, Super Brands produced a famous report in which they put on the cover of the report some famous brands represented by the appearances of the products sans the brand names. So you had the Jif lemon without the word Jif, and so on and so forth. And the report was entitled "Some Brands Fly, Some Brands Die. Why?" ? And the point that was made by that cover, very forcibly, was that everybody knew which brands they were, even though the names didn't appear. I mean, another example, of course, was the Coca-Cola bottle. You know, there were a series of well-known brands like that, but everybody knew which ones they were, even though the names weren't there.
Yes.
And let's get down to brass tacks. The proposition in this case is you could take Thatchers off the can and people would still recognise it. And that's what the judge found. And it's a finding of fact, isn't it?
What I'm saying on the respondent's notice is that you would need good evidence for that.
So you say there's insufficient evidence to justify that finding?
Yes.
Okay, that's clear, thank you.
And the reason is because when a sign is applied to all parts of the packaging, you need education to show that all parts of the packaging are acting as a trademark. And this brings me to Respondent's Notice 4, and I foreshadowed this because remember what I was saying about the link having a low hurdle, and if that's the case, then you need to put more emphasis on the unfair advantage bit. Another way we say of reaching the same conclusion is to find that there's no link because you place a greater emphasis upon the causal elements. Now, in this case, the causal bridge, so to speak, was built from the commonality of the non-distinctive descriptive terms, because she held that in 131 or 134. It's one of those two, and we say, in the respondent's notice, that was improper, because you should only find a causal link when the bricks of that causal link are things that have a trademark significance. And so you shift which part of the analysis does the heavy lifting so as to reach the final conclusion that there's no unfair advantage overall, because you pay greater attention to the causal functionality. I wasn't going to spend any more time on any more of those 3 points unless my lords and my lady have any other questions.
No, thank you very much.
In which case, I might ask my junior just to deal with the 11.2b point.
Yep.
Running out of space somewhat. So the section 11.2b defence is one which the judge made no finding on because she didn't need to in light of the findings she's already made. And indeed, as is the case with due cause, it is quite common that simply the section 11.2b defence will be coterminous with other issues. So the first point I want to emphasise is that we acknowledge that this will be relevant in a fairly narrow scenario, but there is a way through, which I think might be worth starting with first the statute and then factual findings of the judge.
Yep.
The statute is at Authorities Volume 1, tab 3, page 22. And it reads 11.2, a registered trademark is not infringed by B, the use of signs or indications which are not distinctive or which concern the kind, quality, quantity, intended purpose, value, geographical origin, the time of production of goods, or of rendering of services, or other characteristics of goods or services. And we don't need to worry about C, but we do need to worry about the bottom lines, which say provided the use is in accordance with honest practices in industrial or commercial matters. So we put our case on this, firstly on the basis of the factual findings by the judge, that what was similar are elements which are not distinctive, or so on. We've looked at this before, but if you could just again turn up paragraph 1 through 4, which is tab 7 of the core bundle, page 144. And she says, I've also found that it has a low level of similarity with the sign, and what you rely upon, those elements which I have found are similar are either not distinctive because they're descriptive, the text, or are ubiquitous, the limited colour palette, or are commonplace, the use of lemons and lemons on lemon flavoured beverages. So whilst she didn't use the word indicating characteristic, she hadn't got to consider this statute, that this particular statutory wording. My submission is that in her finding that the lemons and lemons on lemon flavoured beverages is commonplace, that equates to a lack of distinctiveness or the indication of a characteristic.
Yeah, but this ties in with the debate we were having earlier, doesn't it? because it depends how you characterise the sign. So if you're right in your submission that upon the Aldi product we do not find a single sign, but we find a multiplicity of signs, then that assists you to say, well, the ones of which there is the areas where there's resemblance, it's a use of non-descriptive signs. But what if the judge is right, at least to the extent that you are to regard it as a totality? Where do you get to there?
So that's the first point of, I think, the two hurdles which we, I say, can elegantly leap over, although we accept that there is a point of debate there. This was something that was addressed below in relation to whether Section 11(2)(b) applies if you only have some descriptive elements of a composite sign, which is what we have here. What was put against us below was a reliance on the Coombe case of Vagisan, effectively that you could, the finding in that case was that you can't sort of artificially dissect a mark. We said that that's a very, very different situation where you have a single word, whereas here we have a multitude of different graphics and elements. And we rely on the fact that the judge found that the only similarity was in those descriptive elements, to mean that effectively that can, we only need to a defence for operative similarity, which is, as a matter of fact, these non-distinctive and descriptive words. So if we cannot rely on this defence, it effectively means that by virtue of pleading the sign as something that includes a distinctive element, a proprietor would never have recourse to Section 11(2)(b). Now, we relied, now there is fairly little case law on this, especially in relation to composite signs. We did rely on the Scottish case of Tomatin, where there was a composite.
Yeah, that's not one I'm familiar with, so can you take us to that?
Yes, so it's at Authorities Bundle 4. It's the first tab. It is only a first instance decision of the Court of Session out of house. You can see the signs at page 130. These are the figurative composite signs.
Sorry, can you give me the page again?
Sorry, 1130.
130.
So we've got the figurative, paragraph 9, we've got the registered figurative mark on the left-hand side. And what happened here is there was a registration of the sign on the right-hand side, and that then gave rise to an infringement claim. So I mean, it's a fairly
Sorry, I'm slightly lost. So the trademark is the 2018 one, yes?
Yes.
When judge says per UK and then the long number ending in 610, what does he mean by that? Because I would assume that was a reference to a registration.
Yeah, so that's the sign complained of, and it was a case where that mark had been registered, and the proprietors of the earlier mark, having seen that had been registered, and then investigated what the there was a planning application.
Oh, right. Okay.
It's effectively a clear time of action.
Understood. All right. Thank you.
So the probably reference worth picking up briefly is at page 1201 and paragraph 290. 326 and 327, the cases, the Yorkshire Rose case, Samuel Smith Brewery, as well as Sky case, they referred to the judge, so they referred to the right case law.
I'm sorry, it's my fault. I've lost the reference again. Can you give it to me?
So, page 1209, you can just see that the cases that the judge was referred to included Samuel Smith.
Right, yes.
And then the consideration of the defence is at the next page, 329 and 330.
All right, well, shall we read that to ourselves? Can you enlighten me? How does this assist us?
So it assists us simply as a precedent where a composite sign, which includes some distinctive elements and some descriptive elements, has been found to benefit from the Section 11 to be defence. I appreciate it's not.
But I don't quite follow that because Tomerton was geographical.
Sorry, it's well, it's geographical and therefore it designates a particular place.
Yes.
So the test is the point. What I get from Tomerton is that the sign as a whole does not need to be completely indicative, whether that's of geographical origin or some other characteristic.
Well, trading company was plainly non-distinctive. I suppose you could say that the device of the sort of the building, the cross section through the building, maybe had some no level of distinctiveness.
So that's why I took you to the assessment of the mark at 290. Really, this is the point. If an absolutist point is taken against.
Yeah, but sorry, it's my fault. I'm not articulating my puzzlement. Let me try and express it more clearly. So, the gravamen of the claimant's case in the Tomerton dispute was there's a likelihood of confusion, alternatively section 10.3 infringement, because of the commonality of Tomerton. But the problem that faced, as the judge explained, I mean, quite why it takes 350 paragraphs or something. No, 395 paragraphs. The problem with that case is that Tomerton was the place. So it's always going to be a difficult case for the claimant to sustain. And as soon as you start looking outside what's common, and the problem with that being that it's a geographical designation, there's no commonality at all. So even if you suppose that the roof and walls device is distinctive, doesn't help the claimant because it's not present in the trademark nor anything like it.
Well, that's exactly my point. The only commonality in this case, as in Tomerton, is in the non-distinctive elements, and that's a finding of fact by the judge.
But what I'm putting to you is that in that case there was no commonality in distinctive elements at all.
Well, again, that is my submission, that the finding of facts of the judge is that the commonality is in matters that would fall within section 11(2)(b).
All right. Okay.
So we've got lemons for lemon cider, the words cloudy lemon for cloudy lemon cider. Whilst it's not quite the same part of 11(2)(b), the thrust is the same in that the only commonality was in, as a matter of fact, parts of the sign and mark which are descriptive, non-distinctive, or indicative. So that's sort of really how it's put in on that totality basis. But even if you were to go back to the statute itself, there's no wording saying that the entirety of a sign needs to be fall within the non-distinctive, descriptive, indicative characteristic, for example. We say we can rely on this because the bits that matter, the bits that give us similarity are. So that is the first hurdle. The second hurdle I have to address is the honest commercial honest practices in industrial or commercial matters. Obviously it's already been acknowledged that section 10(3) is.
Yeah, but what do we do about that if we get into this territory? Because this is a complete absence of findings by the judge. I mean, I assume she was referred to the usual checklist, and one might have expected her to run through the checklist and then reach a conclusion. But there are no findings whatsoever, and that's a problem for both sides if we get into this territory. So what do we do?
So in my submission we have, whilst we don't have factual findings on everything that might be relevant, we have enough given the test that we have to meet. And
but it's a multifactorial evaluation, and in the first instance it's for the trial judge to undertake that, but she hasn't done it. So what do we do?
Well, based on the facts that she did find, my submission is that you can make that assessment yourself and find that it is in accordance with honest commercial practices.
Right, so can I be clear? What you're saying is that if we get into this territory, you're inviting this court to undertake the multifactorial assessment itself on the basis of the judge's findings of fact.
Yes.
You're not inviting us to remit the matter.
Well, I would put that as a secondary submission if you feel you cannot undertake the matter yourself. But if we look at the findings of fact that we actually have, my submission would be that there are enough. The key elements are, of course, that we've already identified. What is similar is the non-distinctive matters. The factual finding, although I appreciate that the submissions I make are going to be somewhat dependent on other elements of the grounds being used. With the finding of intention that we have, specifically there was no finding to take advantage of the goodwill and reputation. That's something that is in accordance with honest commercial practices. My learned friend made clear that there's no allegation that what Aldi has done is fraudulent. I think he put it as some people might find it objectionable. There's a reference in the judgment to having taken legal advice and trying to be a safe distance.
Yes, but the reliance on legal advice doesn't assist you if you're unless you're waiving privilege, which you're not.
No, I mentioned it's one.
I mean, I've been into that in the case law, and as I'm sure you know, unless you disclose what the advice was and upon what instructions, how can you rely upon it?
Well, it's one of the factors, as you're aware, 732. And the phrase I wanted to emphasise over the page, the quotation paragraph 61. Lastly, the condition requiring use of the trademark to be made in accordance with honest practices in industrial or commercial matters must be regarded as constituting, in substance, the expression of a duty to act fairly in relation to the legitimate interests of the trademark owner. And that, we say, is particularly important because it's not just a general, vague test of fairness and honesty. It's with respect to the legitimate interests of the trademark proprietor. And we say, for reasons already discussed in other grounds, that legitimate interest does not extend to stopping other traders from using lemons on lemon products, referring to Aldi lemon cider, etc. We know from marks that that's other marks that they've failed to get registration for, that really that's the monopoly that they would like to have, but that's not the monopoly that they've got. And taking really into account the absence of any factual finding of anything fraudulent, nefarious, careful hoop of putting forward a product which is not going to infringe, that we say together with considering the legitimate interests is enough to find honest commercial practices in this case. And that's a different test to unfair advantage, so we shouldn't really need to get into the dichotomy quite as much, but certainly if you consider if for example, unfair...
Yeah, but again, you get into a paradox, don't you? Because we only get into this if there's already a finding of unfair advantage, brackets without due cause. And so the proposition is that you can have a defence which justifies the unfair advantage, even though establishing that defence requires you to show that you've acted fairly in relation to the legitimate interests of the trademark owner. Now, how is taking unfair advantage of the trademark's reputation acting fairly in relation to the legitimate interests of the trademark owner?
Well, this is really how we get back to L'Oreal and what unfairness
yes, it always comes back to that. Yes.
So, what Lord Justice Jacobs said in relation to following the ECJ Court of Justice's decision was, it's unfair because the court says so. He clearly didn't think it was actually unfair. And in my submission, there is that this scenario where this court might feel bound to say there's unfair advantage because L'Oreal says so. But in reality, when you look at what is honest commercial practices, what Aldi's done falls within that. I'm afraid it's hard to escape L'Oreal in a lot of issues in this case. But if it were a deliberate intention to take unfair advantage, then yes, that wouldn't be a scenario that would fall within honest commercial practices. But it's not being suggested.
Right. So in other words, one can square the circle by taking the example of an inadvertent taking of unfair advantage.
Yes, because that inadvertency may well be within the honest commercial practices and the legitimate interests of a trademark consumer.
Okay.
That I think is everything I wanted to say on that point. Which I think concludes everything we have to say on the rest of the notice.
Thank you.
My lady, that's it.
Thank you very much. Mr.
May it please my lordships and my lady, I'll reply, if I may, in the same order as my learned friend's address to this court. Nothing I'm going to say is of enormous length. It's just a number of, I individual points, if I may, that I would like to respond to. So the first point is in respect of yes, first of all, the Strongbow point, where the objection was taken that we didn't allege in the pleadings that Taurus, in effect, or this Taurus product, sorry, no, the Taurus range, infringed Strongbow's rights. First of all, the Strongbow resemblance comes into play at 2 points in the argument. The first point in the argument, it's part of the factual background of the suggestion run by the defendants that this product did not significantly depart from the appearance of the existing or pre-existing Taurus range. And it is the fact, and indeed was not contested, that there is a resemblance and a strong resemblance between the range as it stood then and the Strongbow product range. And whether or not that gives rise to any possible complaint by Strongbow isn't relevant, that assessment, in my submission. Secondly, the second point to which it comes in to the argument is at the point where we are considering, as relied on by the defendants, the relative sizes of the sales of the other parts of the Taurus range compared with the Cloudy Lemon product complained of. Now, we were not concerned with, indeed we're not concerned with any issue as to whether or not what Aldi did or did not breach legal rights belonging to Strongbow. In fact, it would be a prerequisite for there to be an argument of such a breach that Strongbow happened to have the right to registrations. In other words, they happen to have registration not just of, one would expect them to have registration of the word Strongbow, and so things like the Archer device.
Yes, but as you're acknowledging, not every trademark proprietor registers their packaging.
Not every, so, and the other factor is Strongbow are suppliers to Aldi. There may be good commercial reasons why, even if they had some theoretical legal complaint, they might not think it worthwhile to pursue it, because it might upset a worthwhile customer. So we weren't really concerned, indeed we aren't concerned at any point in my submission with whether or not what they did breached rights belonging to Strongbow. However, when it comes to considering as a factual matter the scale of their own brand Taurus sales, the objective resemblance with Strongbow is there, and in my submission can't be ignored as a potential factor in assisting sales. I think I don't put it much higher than that. I don't think I need to. So moving on to the next point, which is the issue of the judge's approach to assessing similarity. And I hope I don't misrepresent my friend, or anyway, misrepresent unfairly. I thought at this point he was suggesting that there's a sort of spectrum of similarity and dissimilarity. But I think pretty sure he did use the word spectrum.
Yes, well that's fairly uncontroversial.
It's fairly, yes, but one has to think in context. If you think of a spectrum, literally, that's a one-dimensional range along which you go. So, to take it at its logical degree of similarity with a score.
Yes,
It's a
1%, 1% to 99%.
Like,
Yes.
it's like a credit score. And my submission is, I mean, there might well be cases where indeed that when you proceed from, say, section 10.2 to section 10.3, it actually is linear. But that's not every case, and in particular in my submission, it's not this case. I mean, it's rather different, just contrasting the factual approach that my lord conducted in the Jack Wills case, where the similarity actually rested in the both graphic and conceptual similarity of the bird itself. So that it wasn't on that case that there wasn't even really a reason to consider different elements or give different weight to different elements in the context of 10.3 as compared with 10.2, because both were based on the impression that would be made in people's minds by the bird with the top hat.
Well, I understand that, but where we ended up in Mr. Edinburgh's submissions, as I understood it, was that his focus of what he was saying was on the question of the legal test to be applied when assessing the degree of similarity. He did not dispute, I mean, it's common ground, you'd already accepted the threshold question is the same. He did not dispute that when you move on from the question of similarity, you need to think about the effect of the similarity that you found, and that's a different effect in 10.2 and 10.3. But his core proposition was that in carrying out the assessment of the degree of similarity, the legal test is the same. Now, do you take issue with that, and if so, why?
Well, I do take issue with that, and the statutory language reason for doing it is that the actual test is set out in section 10, subsection 2, for confusion. There's the question that has the threshold question of similarity. I can turn it. In 1.2b, the sign. There's the introductory word because in the chapeau of subsection 2 above. Because the sign is similar, then and so on, there exists a likelihood of confusion on the part of the public. So the exercise under subsection 2, leaving aside the case of identical marks, is actually the exercise of considering, will these similarities lead to confusion or not?
To be sure, I mean, to that extent you're ad idem, but I repeat, where Mr. Edinburgh's submissions particularly took issue with yours was on the question of the legal test that's applicable. And one can, I mean, reducing it in simple terms, I mean, the first question is, why should you be assessing any different axes than visual, oral and conceptual? I mean, at that level, I presume you would accept it's got to be the same.
Yes, except in particular factual circumstances. Say oral may play a part in confusion, not be relevant.
Indeed so, but that's a question of once you've identified the degree of similarity on the oral axis, what is the impact of it? And the impact, I think Mr. Edinburgh accepts, may be different depending on whether you're looking at likelihood of confusion or one of the harms in section 10.3. But we're looking at an anterior stage of the question.
Yes.
Then I mean, as he made clear, where this particularly matters is on the question of distinctive and dominant elements.
Indeed. But then, if we look at the test in subsection 3, then in the words of the section, the threshold test is there because it's in 11.3a. The sign has to be identical or similar. If it fails that, then no infringement of that subsection. However, the statutory language itself does not guide you as to what part similarity plays in the subsequent question which the statute is posing, which is where it has a reputation and use of the sign being without due cause takes unfair advantage or is detrimental. And clearly it is well established by authority that similarity plays a part, an important part, in that exercise of assessment. The statute doesn't guide you as the particular focus of why you're considering similarity, but I would suggest from first principles that you are focusing on whether or not the similarity tends to either enhance or negative the unfair taking of advantage, to take one of the three damages, heads of damage, as they're called.
Yep.
And that a priori, in my submission, is a different inquiry from the statutory inquiry under section 10, subsection 2, exists a likelihood of confusion. And it's an inquiry that may run along the same channels to a large degree, or it may not. But in principle, I submit it's a different inquiry. So I hope that's my answer to the fundamental question, quite how far this leaves us in to get practice. But it is indeed distinctive and dominant elements where this becomes important, because my submission there is the distinctive and dominant elements are particularly important in negativing confusion, but they, in my submission, are likely to play less of a part, or indeed in some circumstances really very little part at all, in the unfair advantage context, and indeed the other 10.3 infringements, because in the context of goods sold in a store that's well known for providing its own brands, which are in-house products which are similar to brands, the customer's expectation is that this is Aldi trade origin in the first place. So that's in a way a given. It's something that the difference in dominant elements is something that reinforces the existing perception. And what you're looking at when you move on to section 10, subsection 3, is of course the link or the connection beyond. So that there was another point which was I wanted to pick up, which is a more minor point on prices, where I just wanted to clarify that at some points in the discussion we were considering what happens if the effect, if by attracting more people to buy the Tora's Cloudy Lemon product, that results in cannibalisation, I think my friend's words, of sales of the core Tora's product. There is, just to pick up on the prices, they are in evidence. I think I don't need to turn them up, but it's in paragraph 12 of Mr. Watkins' witness statement, which is in the supplementary bundle, tab 23 at page 75, and the prices are £3.99 for the 4-can pack of the Cloudy Lemon, and £2.39 for the 4-can pack of the same size of what he describes as the core apple, the Taurus core apple flavour. And just for further comparison, the Thatchers price is described by Mr. Milton as being £1.50 more than the Taurus Cloudy Lemon price. So I take it that would be about £5.50 for the 4-can pack. So attracting, if it has the effect, attracting more customers to buy the Taurus Cloudy Lemon, even if it's at the expense of reduced sales of the core Taurus brand, on the face of it, it will benefit Aldi, at least benefit their top line, their total sales. Whether it benefits their bottom line depends on the respective costs and margins, which we don't have evidence of. The next point my learned friend, in relation, well, if we go on transfer of image, my friend made a point about L'Oreal and Beaulieu and the interrelationship in that case between the comparative advertising directive and the trademark infringement grounds, which of course were subject to different questions to the Court of Justice, but were interrelated issues, and claim and use that as a basis for a submission that since what L'Oreal and Beaulieu was involved with were imitations or replicas, that it should be read in effect as fairly narrowly as that type of product. Now,
yes, although to be fair to Mr. Edinburgh, I had misunderstood the point he was making, because the questions about the comparative advertising directive were particularly focused on the comparison lists, whereas the part of the judgment which matters for our purposes is actually about the products themselves.
The physical
and as he pointed out, they were by that stage acknowledged to be imitations.
Now, what I would say about this case is this Taurus product was an imitation, and deliberately so, in terms of the content. In other words, the content and the flavour, that was accepted, and if we go to supplementary bundle page 95, which is part of the transcript of cross-examination of Mr. Watkins, the right-hand column, page 114 of the transcript, so it's page 95 of the bundle, but it's the top right quarter transcript page. And I'm asking him a question there at line 20. Ignore the first sentence, it's all about some text on the document. So anyway, the Aston Martin response, and Aston Martin were the supplier of the product and of the tastes, or at least they mixed the taste in. So anyway, the Aston Martin response, we have a great match for this liquid, smiley face, we will be submitting liquid, and then I read a superior liquid. So there was a choice there of either something they considered as superior to your benchmark or an exact match, and the response was, please send an exact Thatchers match. And then the volume is given, 600,000 units. So was it your instruction to go for the exact match flavour, or would that have been Laura's decision? That would be an Aldi decision, and there's some poetic license in the phrase exact match. because it is clear that exact match would be impossible without using the same supplier, which in this case was Thatchers, whom at that point we did not have a trading relationship with. And then after the judge's intervention, she asked him whose instruction it was. He says it was my instruction, and I asked him, you went to add your comment about it being exact, being poetic, in this context, because it cannot be quite exact, correct. So, leaving aside the poetry, the product was intended to be an imitation of the Thatcher product. They did their best to do that within the constraints of the materials they wanted to use for it. Now, what my learned friend might respond on that is to say the Comparative Advertising Directive speaks of the exclusion is actually for goods which are presented as imitations or replicas.
Yes.
So the fact that they're silently imitations doesn't cause an exclusion from that directive. However, this is where we come on in my submission to transfer of image, its relevance to that. Because given the finding of link, in my submission, there is the average consumer who views it as, to put it more neutrally than a knockoff or rip-off, but as Aldi's, as it were, essay into trying to do the same thing as Thatcher's product. To them, in my submission, it is tantamount to it being presented to those consumers who draw a link as an imitation, not merely being imited.
I think I understand the point you're making in terms of the facts, but how is that legally relevant? Because there's no defence under the Comparative Advertising Directive being relied upon. No. Equally, no breach of the Comparative Advertising Directive was alleged. So while those questions are all in the background, not least because, or as we were discussing yesterday, the issues on comparative advertising have some resonance with the issues on unfair advantage, but nevertheless they are distinct.
They are.
What's the relevance of this question to the debate on transfer of image in the context of unfair advantage?
Well, the relevance is that the very kind of transfer of image that would take place in a replica or imitation goods case, we would argue, is the kind of transfer of image that will take place in this present case. And I won't go over the factors that I emphasised, but a product being in a store that renounces itself for producing products like brands only cheaper.
So your point, let me see if I can articulate your point in my words and see if I've understood it correctly. What you're saying is that the underlying complaint of the trademark owner is the same in both contexts, both in the comparative advertising context and in the unfair advantage context. The complaint is that the defendant is trading off the goodwill of the trademark proprietor.
It is, and in a way that is not deceptive but is unfair.
Yeah.
That's the complaint. Just as a final point I wanted to mention on L'Oreal and Bellier, I did have a look at the end of General Mengozzi's opinion from the point at which my friend took the court to, where he was discussing transfer of image.
Yeah.
However, this is really for completeness to say this, because he went in a direction, I think, a direction of his own, really, regarding the relationship between due cause and fair and fairness and unfairness, and proposed a set of answers to question 5, which differs quite significantly from what the court adopted. So I just wanted to mention that for completeness.
Thank you.
That it doesn't seem to provide much assistance, as it were, unlike a case where a court has simply adopted an Advocate General's recommendation, and then one can look at the Advocate General's opinion for the more supporting nuances, as were. It may not prove very helpful in interpreting a court's decision on unfair advantage. Now, my next point is yes, the transfer image. This is on whether we, or the extent to which we relied on transfer image at the trial. And I just wanted, your lordships may have this already, but I just wanted to check that in addition to putting this into our opening skeleton, and indeed relying on the monster case, we mentioned this in oral opening, and that is the core bundle.
Yes, well, that was accepted.
That was accepted, and it was fairly early on in the opening. After, it was a bit of housekeeping, and then fairly early on. IPEC trials, as my lords and my lady were, are very compressed. You don't have time for repeatedly the vice of counsel repeating their submissions endlessly to the annoyance of the court. There's
yes, you don't have time to do it because you've only got 2 days. Yeah.
Yeah. So it was clearly articulated in my submission. Sorry, I've got a note which I just need to check. A note to a paragraph judgment. Yeah, it was only to the judge's reference to L'Oreal and Villiers in paragraph 124 of the judgment, which is page 140 of the trial bundle. And the suggestion from my learned friend was that implicitly, that implicitly involved the judge considering transfer of image and the probabilities thereof. In my submission, that there isn't a basis for reading it in this way. That there is no mention of the transfer of image as a concept, but more importantly, that there isn't here or elsewhere an addressing of the probabilities from the link of whether or not this will lead to a transfer of image, or whether or not that word is used, a transfer of the benefit from the reputation and marketing efforts. So I rest on my case, my submission, that on that, that the judge did not, on the face of the transcript of her judgment, consider that important ground. My next, sorry, I'm sorry, this is sort of, I am going at some speed.
That's good.
But I'm really only picking up points where I'm not just sort of coming back and repeating my disagreements with my learned friend. I'm trying only to pick up points where there's something additional to say. Yes, this is the question of the reliance the judge placed on Aldi keeping or intending to keep a safe distance from, in this case, Thatcher's rights. And the problem with that, in fact, there are two problems. One, which was identified by my Lord Justice Arnold, which is that there are two, if you like, safe distances to keep. One is, am I going to cause confusion? Is there a risk I'm going to cause confusion? And there's potentially another safe distance to keep, which is, am I going to do something, whether I intended or not, but am I going to do something which will risk a transfer of image, which will risk my product being seen as a substitute for, thereby benefit from the image of another trademark. And I'll put it this way, there's no clear statement. What Mr. Watkins said was that they didn't want to infringe people's rights, so they took legal advice, and if the lawyers told them they couldn't do it, they didn't do it, which is fine as far as it goes. But of course, since they didn't disclose what legal advice was taken on this product, it doesn't get them very far. If they had disclosed a legal advice that said, well, we've considered carefully A, whether it breaches under section 10, subsection 2, and whether it's confusing and we think it doesn't, and B, we've considered section 10, subsection 3, and we think it doesn't, or with these changes it won't, well, that would be a completely different set of facts. But there's nothing like that. I mean, whatever advice they took, they have maintained privilege in it, and intentionally so. That's stated in Mr. Watkins' witness statement. So a careful decision taken on advice. So in my submission, you can place very little weight on this concept of them steering away from trouble as being something to take into account in assessing what they in fact did do. Moving on again, moving quite quickly to my learned friend Miss Wickenden's submissions. First of all, her submissions on detriment. In my submission, the issue here is that, first of all, we did allege substantial differences of composition. In the pleadings, it's alleged in those broad terms, but in the witness statement, it's extended. More details are given on the differences in composition. It goes beyond a mere difference of taste.
But what's the relevance of that? I mean, I don't understand it to be in dispute. In fact, there are differences in composition. But what's the relevance of that?
Well, it's relevant in two ways. One is that when you look at, it's not simply evidence of, well, I tasted it and in my view it's different. It's evidence of tasting it and it's different, has less full mouthfeel, for example. because of the difference.
Yeah, so that's a question of the consumer perception.
It goes to consumer perception. Indeed, it goes to consumer perception, but it's a more factual support for that. In fact, we at the case management conference, my clients applied to have use expert evidence on this subject, but the Judge Haycom rejected that on case management grounds. So had to make the best with without the expert evidence. But on the other hand, it's more substantial than just a sort of vague, oh, it may taste slightly different. We didn't allege in terms, well, it tastes inferior, because that's an extremely difficult allegation to make out because of the subjectivity of different individuals' tastes. You then get into a question of, how do you prove that? Well, you have to set up tasting panels, and
well, quite
90% of people say it's worse, or 30% say it's better.
Which brings one back to the question, assuming that it's accepted that a difference in composition leads to a difference in taste, not necessarily inferior, but different, what's the relevance?
The relevance is that it is likely to, or at least risks putting off some people, some customers who either are familiar with the Thatchers product or might become more familiar with it in future, who sample the tourist product and say, well, this is not for me, and it is entirely plausible that such customers will, to a significant extent, or may to a significant extent, be put off from the Thatchers product.
Well, the argument against you is you can imagine how that happens as a matter of causation if there's a likelihood of confusion, because people taste the tourist product, they don't like it, and because they're confused between tourists and Thatchers, Thatchers get the blame. But we're here operating on the basis that there's no likelihood of confusion, so how does it operate?
It operates, I would agree or accept, at a weaker level, because if you think it's the identical product, then you're going to say, well, this very product. However, if you think this is a replica or imitation of the Thatchers product, and it puts you off, obviously there are two alternatives that the consumer might think of. The consumer might say, oh, well, this is obviously because it's an Aldi product. What do I expect if I buy a cheaper product from Aldi? Or the consumer might take Aldi at their word, like brands, only cheaper, and say this is a true reflection of what the Thatchers product is going to taste like, or does taste like. So in my submission, it's entirely plausible to have damage arising from that cause. And to complete on this topic, my lord, in discussion with Miss Wickenden, asked what was the relevance of the composition difference and the labelling as such. And in effect, if the punter never finds out that the punter has been deceived, what is the harm? Might be a way of putting it.
Yes.
Well, I would say in this sort of context, there's always a risk. There's always a risk in my submission of this sort of thing coming to light and causing damage. And again, a very similar point your lordship put to me, in the case of confusion, it's well accepted that the fact that the proprietors is at risk of things going wrong with the defendant's products where there's confusion is a source of potential damage to the proprietor. Now, I would accept that in this context of Section 10, subsection 3, it's a weaker risk, but nonetheless, I would say by analogy, such a risk does exist. And that it is sufficient to amount to a detriment, or at least a likely future detriment to the reputation of the mark.
Is risk sufficient in these circumstances?
Well, I can't see what, with respect, why it shouldn't be.
Doesn't have to be actually detrimental.
Well, it says is detrimental to the repute. Is indeed the words of the statute. But in my submission, you should look at the potential future damage in this context, as well as just immediate and present damage. Now, that brings me on to I don't want to spend really very little time. Ms. Wickenden addressed the court on this issue of two-dimensional versus three-dimensional, and I think my lords and my lady have sort of got the points. I just wanted to defend myself from possible accusation of heresy in seeking to compare, in a trademark infringement case, the sign with the mark as on the claimant's product rather than the registration. And it is completely clear that correct comparison always has been, that the correct comparison is between the registration and the defendant's sign. Not that the basis of comparison is not between the claimant's product on the market and the defendant's sign. That's the basis of comparison and passing off action. However, that doesn't mean that the way in which the trademark is used is irrelevant, because, for example, in the Specsavers case, the fact that the claimant had used their mark in green enabled them to take a monochrome registered mark and rely, as it were, more forcefully against a sign which was in green. So the way in which the mark has been used does come in, and therefore the fact that Thatchers, in common, one would say, with virtually everyone else in the drink industry, put their two-dimensional marks round the side of cans is something will be known to the consumers.
Yeah,
and
it's the paradigm example of notional fair use of the trademark.
Indeed, yes.
Because that's what, in fact, everybody does.
Yes. And there's a sort of linked point. I mean, it was a different point which was to do with further point, which was to do with seeking to excise, in effect, what I understood it to be the central element of the Aldi can, and treat that as the sign rather than the whole product, the whole can, or the whole, well, let's be strict, the graphics on the entire surface of the can. That's a slightly different argument, and in my submission, there is no reason, I suppose I'm responding to Mr. Edenborough's comments as well, where he referred to it's like a three-dimensional mark where you need the public to be educated to attach brand significance to different elements of a particularly if it's, for example, if it's the shape of goods, then the public, you don't assume immediately the public will attach brand or origin significance to the shape of goods. There has to be something more to show that that's the case. However, the practice of putting, if I use neutral phrase, sort of fancy patterns and ornaments, if I can use a neutral phrase on the whole of the cans, or at least the whole of the cylindrical surfaces, where the tops and bottoms don't bear it, seems to be pretty universal in the beverage industry, whether alcoholic or non-alcoholic, like the Coke can my lady mentioned. And there really is no reason why members of the public, consumers, are not going to treat fancy elements on any part of a can, at least on any part of the visible surface of the can, as being part of the branding. So I think when we come to, I draw attention to the fact, and I won't go through it at length, that we do have a reply skeleton argument.
Yes, thank you.
In relation to the points that my friend, well, both in relation, that's core bundle, last tab, tab 14, page 264.
Yep.
And that deals with the
firstly, departure from
the departure. I don't want to add much to, well, there's an interesting statutory point here that the 2023 Act would have relaxed the test for departure.
Section 6 is not in force.
But Section 6 was not in force, and the outgoing Conservative government neglected to bring it in force in time, and the incoming government has cancelled the commencement order.
Yes, it's on pause.
So, without entering into the politics of it, the Section 6 of the 2023 Act is not in force and unlikely to come into force in the foreseeable future. So we are still dealing with the identical test that this court dealt with, both in industrial cleaning, of course, which went one way, but more pertinently, Warner and Tuning.
And you say this is on the Warner and Tuning side?
Yes, this is heavily, I mean, L'Oreal and Bleu must be one of the most heavily cited Court of Justice decisions in our trademark jurisprudence. So it's in an area where departing from it would cause quite big perturbations in this area of the law, whether they're good or bad. But similarly, as Warner and Tuning, that's more a matter for the legislature to tackle than for a judicial upheaval.
Well, what do you say to the suggestion that I think Mr. McEader relays, that what was required was maybe not so much a wholesale departure from L'Oreal and Bleu, but what one might call a recalibration of it?
Well, the problem with that is what exactly is that recalibration? I mean, he wants it to be departed from, insofar as it's necessary for his case on the facts of this case.
Well, indeed, yes.
But that's not a... You know, in my submission, the court is going to say, well, this principle, as enunciated by the Court of Justice, is wrong, or sorry, not wrong, but we're departing from it, and we would want to substitute a different principle.
Yeah, all right. I mean, that's an obvious target for his submissions, as I pointed out when he made it. But his answer to it, I think, eventually, was to say that what's required, if one's not going to simply accentuate the facts of the case, is to adopt the words of Lord Justice Lewison in a different context, for the court to say that when we say unfair, we mean really unfair.
Yes, but that's. I can see one could say that, but it's not easy then to apply it for other courts to apply that. Well, we should be more cautious. At the moment there does seem to be reasonable clarity of the kind of cases where unfair advantage is found. I mentioned earlier the Argos and Argos case as an exemplar, in fact, where unfair advantage was not found. It's in the bundles, but I didn't take time to turn it out. But I hope I didn't summarise it unfairly. But that's a case where they charged money, or they got advertising revenue from accidental visitors arriving at their website who were confused by the word Argos in their argos.com domain name. And this court thought, well, given they were suffering the inconvenience of all these unwanted visitors and got no other benefit, then just getting a bit of ad revenue to pay for the bandwidth didn't sound too unfair.
So,
going
back, I appreciate the point you make about Argos, but going back to what you were saying immediately before you went on to Argos, do I understand your submission to be to this effect, that whatever people might have thought back in 2009, what we now know in 2005 is that the roof has not fallen in? It hasn't proved to be a disastrous decision in terms of its impacts on industry across Europe.
No, and it doesn't, for example, lead to all lookalike goods in whatever circumstances is unlawful. It hasn't led to that, and in my submission there's no reason it should, because of the requirement to establish the relevant link.
All right, and does that then take us on to the respondent's notice point? Yes,
and there again we have we've set out our response on the respondent's notice points in this skeleton, and it seems, with respect to my learned friends, it's a point that comes up again and again in many guises, attempting to discount all but, if you like, the central elements of the tourist sign, or indeed, in this case, seeking to discount all but the central elements of the Thatchers trademark. And the fundamental fallacy which runs through it all in my submission is that they proceed from the proposition that putting lemons on is descriptive, which as such is not a proposition I dispute, to then asserting that having pictures of lemons and leaves and in this particular arrangement and having them arranged relative to wording in a particular way is non-distinctive. And we do make pointless, maybe some analogy with the Lidl case. In that case, Section 10.3 infringement was found and upheld by this court in respect of, I think, what was called the word mark, or the mark with the word in it, with the word Lidl in the centre of the mark. Perhaps in view of the looks I'm getting, maybe we should turn up Tesco and Lidl to look at the marks I'm talking about.
Not everybody's intimately familiar with the effects of that case.
I very apologise for causing puzzlement. So Lidl and Tesco is yes.
Bundle 2, tab 15.
Tab 15.
Is I mean, that's the course of appeal. I mean, you may, is it the course of appeal you want, or the first instance?
Well, I think either will do for this point. Well, actually, the first instance, tab 14. Actually, the only defect of this is it's in black and white, so which makes it a bit difficult.
Doesn't really help, does it?
Difficult to follow. That there were the colouring actually is important, but the point I'm making is that one of them is called the wordless mark, and the other was the mark with the word "little" in it. In fact, in a particular stylized way. However, when it came to the alleged infringement, which I suppose one can see at the top of the next page,
the wordless mark was invalidated.
Indeed.
It didn't matter from Lidl's perspective because they still won on the mark with the word, even though Lidl did not appear in the signs complained of.
That's
your point.
That is my point.
Yeah.
So despite the peripheral matter, which had it been was found to be invalid, not on grounds of lack of distinctiveness, was found to be invalid. There's no requirement that Thatchers should be able to register the peripheral matter.
Yeah, but one's got to be very careful about comparing cases on that basis, because one of the controversies about that case is arising out of the allegation of bad faith, which was upheld both the first instance and on appeal, is people say, oh, well, why on earth was that bad faith? Because they could have registered the wordless mark and the little mark separately. And what would have been wrong with that? Because the wordless mark would have been fine as a registration on its own. The problem with that is the argument presupposes that the wordless mark was inherently distinctive, because otherwise it's a bootstraps argument. When you look at the judge's judgment, she did not find that it was inherently distinctive. What she found was that there was acquired distinctive character, as you point out, even in the elements that did not include the word little. But there is no finding that it was inherently distinctive. And therefore, if you're starting to try and draw conclusions from the facts of a different case, one has to be very careful about it.
Indeed, I fully accept that, my lord. I think that the extent to which I rely on that particular point is one strand of my friend's argument seems to be, oh, well, you couldn't have registered the mark if you had excluded the central elements, the mark in suit. Now, whether that's right or not.
What he says you've tried and failed.
Well, that's actually different registration, but
right.
And it could well be that with evidence of use, but even assuming that's the case, that is not the answer to either the question of whether the mark has enhanced distinctiveness or has a reputation, because it comes back to the same fundamental point, which is confusing the combination of features with individual elements of them.
Yep. All right, I understand that.
And it's perfectly possible to have individual elements which are taken by themselves, commonplace, totally descriptive, whatever you choose to describe them, not distinctive, but bring them together in such a way that the combination is distinctive. And again, it may be probably treading over old ground again, but we go back in my submission to the large number of different ways in which lemons have been depicted in the products that were examined in the course of Thatcher developing this particular trademark. And there are ways in which the brothers one is particularly lemony, good communication of lemoniness, but completely different. So I think that brings me on to the final thing, which is section 11.2b.
Yeah.
And there's a sort of similar argument there, which is, the suggestion is, well, because these are lemons, they're descriptive, ergo they're covered by the defence. They're indications of, well, products, not in fact the product's content, as it happens, but at least the product's taste. But again, well, the word lemon, of course, is an indication of lemoniness, but you don't need to use lemons in this particular way or layout to communicate or indicate that it's made from, or at least tastes of, lemon. And I just want to draw attention, in case this is a matter in which this court is keen to go further, that we have in fact addressed this subject in our trial skeleton, which is in core bundle tab 11, page 218.
Yeah, well, that was the point that Ms. Wickerton was explaining about the reference to the Coombe case.
Yes, indeed. I mean, I appreciate that the Coombe case is slightly different because there he was dealing with, if you like, a point of principle with the letters VAGI embedded in a mark. And didn't think that they were an indication, in this case, of the characteristics of the goods, which were the treatment. Is the word sign Vagisan. But a similar point in my submission runs by analogy, in that is this material, is this an indication of the type of the characteristics of the goods? And my submission is it's more than that.
Yeah, all right, well, that point we understand.
You can,
if we get on to the question of honest concurrent, honest practices, what do we do about that?
well, that's very simple according to our paragraph 106 of our skeleton, is that they didn't plead it. However, if that's not a sufficient answer, for present purposes, I will deal with this more with the substance of it. If we get onto it, obviously it will be against a finding that the in the context of section 10 subsection 3, that in effect the use made of the peripheral, regarded as the peripheral matters on the Aldi can, led to an unfair benefit in infringement.
Yeah, so you say therefore they lose on honest practices.
Yes, I would say it's very difficult to see a route.
Are you agreed with Mr. Edinburgh that this court can and should make its own assessment if we get to this, rather than remitting?
Can I just check my instructions on that point? My lord, yes. I mean, otherwise, potentially, we might end up with a trial just on that point.
Okay. Anything more?
Can I just check the instructions? Just one more administrative thing. I'm told that the 4-can pack of the Taurus is the last that we have, and it can't be replaced because they've all sold out and been drunk in public. So
I will keep it in safe custody.
So please don't
Fortunately, it's a secure building, at least on the judicial side.
I have a right to reply.
Yes, you do. Yes.
I'm going to be incredibly quick, if I may. The very first point is that not all lookalikes would be bad because you need to establish a link. But the way in which the link has been formulated is that all lookalikes would have a link, because the link is a low test in the way in which it's been promulgated so far. The second point, and it's accepted that not all lookalikes should be bad, so therefore there's a logical inconsistency there. The second point is the Tesco matter, and in the Court of Appeal, and I'm just going to give you the reference, Authorities Bundle 2, tab 15, page 622, at paragraph 128, this picks up on a point my Lord Justice Arnold made, is that you have to be very careful with respect to all the facts. And in that case, the Court of Appeal says, as I have also noted, Tesco do not now dispute that if the representation alleged by Lidl was made, it was false. So that was one of the factors that led into the fact that there was unfair advantage, the falseness of the price comparison representation. I've only given you the edited highlights of that. There's more behind it, but that's sufficient for your note now. The third point that I'd like to make is in our skeleton before this court, which is found in the core bundle behind tab 4 on page 79, paragraph 72. This relates to the submission that my own friends just made with respect to the labelling with and without the words Thatcher in the middle. This is not exactly the same because it's blue, but otherwise you can see the point that's being made in that paragraph about what we say is the unregistrability of things without the Thatchers. And
but how does that help? Because that's a subsequent packaging design, which no doubt didn't have the use that had been made at the previous one.
No, except that point.
And as you point out, it's materially different because it's got a lot of blue in it.
It's got blue. All we're trying to say is, if you read the whole paragraph, I think what they did is they managed to secure registration with it, with the wording in, but not without the wording. It's only illustrative. And that's as far as I can take it.
Yeah, all right.
And Maloney Jr. has a very short point on 11.2b.
Yes.
So I think 2 points were said against me that firstly that it was not necessary to use lemons and therefore the section 11.2b defence isn't engaged.
No. The proposition was that it's accepted that lemons per se are descriptive. But what's not necessary is to use a constellation of lemons and lemon leaves and the other features. Well,
the point is whether it's necessary or not doesn't matter for selection for section 11.2b.
Yeah.
There's a comment there, I don't need to turn it up, but for your note in curly paragraph 17.023, which is at tab 41 on page 1625. The other point was that the lemons, etc., are not exclusively descriptive, non-descriptive, indicative. In my submission, the fact that we get here, and the fact that this provision exists, must mean that there is no requirement of exclusive descriptiveness, for example. Otherwise, there could be no likelihood of confusion or unfair advantage link, etc. It must be that this applies in a situation where there is a dual use, one which engages trade provisions and the other where it's descriptive and indicative. So that's also no reason for this defence not to apply.
All right. Well, thank you all for your submissions. You've given us a lot to think about. We will obviously be reserving our judgment. Don't expect it as a Christmas present. It will be sometime in the new year. When you get the judgment, as I'm sure everybody knows, it will come first in the form of a draft for two purposes. Firstly, to check for typos and transpositions of claimant and defendant and things of that nature, and wrong dates, but not to re-argue the case. Secondly, so in the hope that you can agree in a consequential order, or if not, prepare brief written submissions. And in the interval between receiving the draft and it being handed down, the draft is under embargo, and I'm sure you all now know that the embargo is to be strictly observed. In terms of the handing down, that will be done remotely, no further attendance required. Thank you again.
Court rise.